Fixed case Act 215, item 33, FA 52 of 2026, and analogous cases from the hot list of 1030.
बताइए आपका लीड केस कौन सा होगा?
Item number 63. Their NCR is received in that.
फर्स्ट अपील नंबर कौन सा है?
Therefore, 36 of 26.
36 और
26. First of all, 36 of
26. आपका लीड केस कौन सा है?
78.
FA number 78 of 26. Claimants का. ठीक है. आपने कोई नोट्स है? आपने कोई नोट्स फाइल किया है?
File
63 है
हाँ. और एक 36.
ये 478.
same substance.
आपका जो बैच है तो सारा का सारा रेस्पोंडेंट सेम है आपके बैच में?
फैमिली एक ही है.
आपके बैच में रेस्पोंडेंट सब सेम है?
हाँ सर.
मतलब कोई सीक्वेंस वगैरह सब सेम है? सेम टू सेम रेस्पोंडेंट्स है?
Respondents जो NTPC केस में.
2-4 केस में रिस्पोंडेंट्स कम है, किसी में 8 है, किसी में 3 है.
नहीं, आपके केस में तो 3 है रेस्पोंडेंट. डेप्यूटी कमिश्नर, चीफ प्रोजेक्ट मैनेजर एनटीपीसी एंड डिस्ट्रिक्ट कॉम्पिटेंट सब में सेम है, क्योंकि हमारे स्टेनोग्राफर को थोड़ा कन्वीनियंस होना चाहिए ना.
वो सेम.
ठीक है, ये सारे में सेम है, लेकिन अपीलान सब में अलग अलग.
अपना एक ही फैमिली से सब में सरस्वती देवी है, किसी किसी में थोड़ा सा.
There is no problem. In your case, appellant is the same,
Yes.
same designation, नाम सब same है. This is your written submissions. ठीक.
Your leadership may kindly come to my detail note second. These are the list of date and event. What actually has happened in this matter, earlier there was a notification for acquisition which finally came to an end on July 7, 2015. That will be serial number 4.
We can see the sequence right
Yes,
from
yes.
1, serial number 1.
So there
तो background बताएं.
background for Kerendari project, we were to acquire the land for purpose of overburden, keeping of overburden of the OPDA. I would say 25th January, Kerendari for money allotted to NTPC. May 16, 2012 and August 4, 2012, Budget notification under Land Acquisition Act 1990. June 10, 2015, re-allotment of Kerendari mining project to NTPC, that is Manwara was famous. Then June 7, 2015, lapse of earlier land acquisition. Now relevant term will be fifth, that is April 29, 2016. Fresh application for initiation of land acquisition procedure. These proceedings were under Right to Fair Compensation Act 2013, so there is no dispute that the Act 2013 will follow. Then June 12, 2019, notification under Section 11 of Right to Fair Compensation. That is the preliminary notification. Because new Act prescribes all social impact assessment, all exercise has to be carried and preliminary.
And which is followed by a preliminary notice.
It will be followed.
Or the social impact assessment is done after the preliminary.
No, before.
Before.
Section 4 onwards it starts, then after doing those things, then 11 comes. Then May 21, 22, June 12, 2019, that is the notification under Section 11 of the Right to Fair Compensation and Transparency in Land Acquisition. Total land acquired in HESA is 84.80 of royalty land. Your leadership will take into consideration the subject matter pertains only to HESA, so far as these litigations are concerned. Other villages were there for this purpose, it is only HESA. Then comes May 21, 22, the reference made to learned court under Section 64. Then
The
comes
compensation was not accepted.
not accepted, so section 64 referral code to land acquisition pricing, that is principal disclosure. Hazaribagh was matter was referred to. Then November 30, 2024, compensation enhanced from 4823
4823 per acre
decimal.
per decimal.
Per decimal. I'm sorry, it should have been mentioned. 4823 per decimal to 11,000 per decimal.
So we are not concerned with the previous proceedings under
No, that's
89.
only.
That's
only
the background.
Background I have given that all things are there. Then enhancement
When was the possession taken?
immediately.
Immediately upon section 11 notification or upon fresh application?
Motion, I will give it back picture for this.
All right. Is determined on the basis of sale deeds.
Yes, exhibit 1 to 1 by 50 under section 26, section 26 determines lays down how the compensation has to be. So that is 1 to 1 by 50. Now these are the details of the
This
sale.
is the principles of determination of compensation under 2013 Act.
Yes, 30.
Is fair market value?
First it comes back, I will place that.
Yes.
First it
There
says
is
that
slight difference between the two.
market value will be the catch point. At the end of the day, it says stamp value first of all. If it is not there, then it says that
Stamp value. Stamp value.
stamp duties. Yes, if I just place it right.
Okay, we'll see that. Let's complete the background.
Yes. Then these are the details what exhibit documents have been made at the instance of the current respondent plaintiff over there. This detailed breakup I have made.
And some of the, only a few of them are from
Two
Teresa.
only there.
Only two.
First two. The leadership will see.
So I can foresee, could be that your argument could be that once the deed of the same village is available, there was no requirement.
No, my argument will be otherwise.
Otherwise.
These respondents were having sale deeds in their name for Teresa for the same period.
Okay.
They concealed this fact, and the Honorable Apex Court in land acquisition matter itself has held that if they have done so, that is how my IA for additional document is there.
Okay. They have responded to that.
They have responded and asked for this.
Okay.
So I will just say, and what will be the impact of 1 decimal, 2 decimals of transaction vis-a-vis large tracts of acquisition. So this detail I have given you, Rishi. Your leadership will
So
find.
date of acquisition is 29th April. That is the initiation. Which
16.
is the date we have to pick.
The catch point is that Act says proposal will be. It does not say when notification is made. Proposal, if I take it, it will be 2016.
29th April 2016.
60. But even for the sake of argument, because I take that way, because now we are at a point which we can take it to be a neutral point for determining 4823. So even 19 is taken, then it says 3 years preceding years. And year has not been defined in this act, but year has been defined under general
Calendar year. Calendar year.
calendar year. That is first. So if it is a 19, then 16 can be taken into consideration for the purpose of preceding 3 years.
Preceding 3 years.
3 years from the date of acquisition. So 19 is the notification, preliminary notice. But it's simultaneously it says proposal.
You cannot take the entire year as a date of reference, as a referable date. When we talk about 3 years prior to this notification, suppose it is on 1st of April, then 3 years would be 1st of April minus 3 years from 1st of April.
My submission for the leadership will be different because the year has been defined and it says the calendar year.
That's right.
It does not say date. 3 years preceding the date of acquisition, it would have said, I could have understood. Number one. Number two, even these deeds which they have presented, 2 of them for Teresa, which they have come forward, if that date is taken into consideration, it will go behind that 3 years. If that interpretation is taken, then these 2 deeds will not have been taken into consideration.
These 2 days.
Yes, it is because
April
it is
8th.
of April 8 and April 13 because that is of June. Notification is of June 19.
No, the application for initiation is 29th April
2006.
2016.
Yes.
You say that
Then
is the
it will go to
referable
13. Then it will go back to 30.
One-
14. I take it will go back to 13, then 29, then the rate values. So when I will be arguing one question, I am just quickly taking the
Yes,
leadership on this. Now, I have taken my, the calculation has been made based on section 26, read with explanation 1. Now this is the only issue that is before your valuation, because acquisition is not disputed, title is not disputed, quantification how it has to be done. Then this is the written submission. The first issue, whether determination of compensation by the report of principal district judge is in conformity with section 26 of 2013 and judicial instructions. May I press it? The land acquisition authority had determined the compensation at the rate of 4823, considering the circle rate of the village taxation along with other factors under Act 2000. We have given the details of the sections.
So the determination is not on the basis of sale deeds.
Not exactly.
It is based on the basis of circle rates.
No, not even that. Circle rate would have gone far less. Far less.
Then further,
I have detailed out. It should be fine.
yes, the
The
plaintiff.
plaintiff respondent raised the objection and sought enhancement of compensation. In support of their contention, 16 sale bids were brought on record, 2 for village Karesa and 14 for vicinity villages. The learned court took the average of 8 highest valued sale bids. The average rate was found 15,376. However, learned court then gave a finding of 11,000 per decimal to be just and fair. That the impugned judgment suffers from gross illegality for the reason no reason has been assigned why circle rate has not been considered, which rather was of the year 2020. So 2020 circle rate was marked as an exhibit and mandates as per section 26A of the Act 2013. Explanation 1 of section 26 of Act 2000 was not considered in its true perspective. Sale deeds for the same village, Karesa, existed, to which claimant himself was a party. The same deeds with respect to the land which was acquired and as such would be the best evidence to a certain value. Additionally, by way of additional document, the appellant has brought on record sale deeds to which one Ramswarup Ojha was a party, which reveals that the rate never exceeds more than 5 to 6,000 as per decimal for the village Karesa. The fact is of material importance and the respondent has concealed this fact before the learned referral.
Ram Swarup Ojha is
He is
one
one
of the
the party and he is claimant witness number 1. Plaintiff witness number 1. Now I have prepared a table chart of next statement. I am just proceeding with it. Best evidence for determination of compensation is sale of acquired land to which claimant himself was a party. It is submitted that in case of area so and so, the Honorable Supreme Court held that the best evidence for valuation of a property is the sale of the acquired land to which claimant himself is a party. The relevant portion of the judgment is produced as in the already reference. I am placing it. Therefore, the transaction relating to the acquired land of recent dates or in the neighborhood lands that possess of similar potentiality or fertility or other advantageous features are relevant pieces of evidence. When the court are called upon to fix market value of the land in compulsory acquisition, the best evidence of the value of property is the sale of the acquired land to which the claimant himself is a party. In its absence of sale of neighboring lands. In proof of the sale transaction, the relationship of parties to the transaction, the market condition, the term of the sale and the date of sale are looked into. It is submitted that claimant Ramswarup Ojha, BW1, has himself executed about 8 sale deeds in the year 2016, 2 sale deeds in the late 2015. However, instead of bringing the same on record, claimant chose to bring on record the sale deeds with respect to the other villages. The respondent have filed interlocutory application. I just missed 2329. I just missed 2329 of 2026, and it should be applicable. It should be applicable. The applicant. and have sought the leave of the report to bring on record sale deeds. The details of the same are tabulated as under. Now these are the sale deeds with details. Fine. All
You
are
say that executed 8 sale deeds.
for various Teresa.
These are all 1 decimal, 3 decimal, 2
This is claimant is a party to it. I am
That's
not,
a
it is not my
claimant is a
deeds.
party, that's right.
Earlier also the deed which your ladyship will find is 2 decimals, which the court has relied 2 pages back. Page number 2, your ladyship will find Teresa 2 decimals. Now it comes, these are the sale deeds that has been executed, and these are of May 16, August 4, February 9, 16. Now your ladyship will find all the consideration value of these deeds.
How is it that your authorities did not go lay
I
hand
am
on this?
PVNL, state is the custodian, state had to adduce. I have explained in my petition under 4127 that when they claimed their immunity for a different acquisition, based on this sale deed, then we came to know that about these sale deeds. After the passing of this, we have been disclosed denied. Now these are the facts. Now consignment of parties of additional document of the application has been filed under Order 41/27 of the Code of Civil Procedure. The Honorable Supreme Court in Sanjay Kumar Singh versus State of Jharkhand, matter pertains to land acquisition and certification, has held that additional evidence removes the cloud of doubt over the case of evidence, and the evidence sought to be introduced has a direct and importance bearing on the main issue. The same ought to be allowed. The relevant portion of the judgment is reproduced as under for ready reference. It is true that general principle is that the appellate court should not travel outside the record of the lower court and cannot take evidence in appeal. However, as an exception, Order 41/27 enables the appellate court to take additional evidence in exceptional circumstances. It may also be true that appellate court may permit additional evidence if conditions laid down in this rules are found to exist and the parties are not entitled as of right to the admission of such evidence. However, at the same time, where the additional evidence sought to be adduced removes the cloud of doubt over the case and the evidence has a direct and importance bearing on the main issue in the suit, and interest of justice clearly renders it imperative that it may be allowed to be permitted on record, such application may be allowed. Even one of the circumstances in which the production of additional evidence under 41/27 by the appellate court is to be considered is whether or not appellate court requires the additional evidence as to enable it to pronounce judgment or of any other substantial cause of like nature. In the case at hand, the sale deeds brought on the court have a direct bearing on the main issue. The sale deeds are not only with respect to the land, are not only with respect to the lands which have been acquired, but are also being executed by the claimant seeking enhancement of compensation. PW1, who is the plaintiff claimant, has himself admitted that deeds were executed in the various Teresa. However, no such deed was brought on record by him. The claimant, taking advantage of the misinterpretation by the state of Jharkhand, misrepresentation.
Misrepresentation.
It will be misinterpretation itself, right?
Misinterpretation.
Yes, of explanation 1. It should be explanation 1 to section 26. Has tried to contain that
Explanation 1 to section
26 of the Act 2013. Has brought on record by way of interrogatory application prior to June 2013. It should be 16. I'm sorry. Prior to June 12, 2016. And hence the same cannot be taken on record. That 3 years rider leadership it would not be out of place to mention that in reply the plaintiffs have not denied the existence of the lien. The argument of the plaintiff is not only barred by stopping but also amounts to material concealment on the part of the plaintiff. The sale deeds marked Exhibit 1 and 1 by 1 are also prior to the cutoff date and hence the plaintiff cannot object to the deeds being produced by the respondent.
As prior to the cut-off date, as per the plaintiff, what do you mean as per the plaintiff?
They-
Cut-off date has to be as per the statute.
Stoppel is fact I am taking here. So they take it as June 2019.
What they take is irrelevant.
So then it
What
will be
is the material date you have to take?
13. I will have to take 13. When I press the statute, I will submit that. It is 29th April 2016 is the proposal when
And there is no deed of 2013. There is no deed of 2013.
No, so it is of 16. So the 16 will be a later date. So
No,
judicial-
why will you take 2013? You will take April 29, 2016, no? Cut-off date?
there are two.
You see, there are two dates.
Yes.
One is of 19, that is the date of notification,
Yes.
and other is the fresh application for initiation of land acquisition proceedings.
That is April 9, 29.
April 29, 2016.
So if I take 3 years,
Prior to April 29, 2016.
it will go to 13.
That's right.
Yes.
But any date prior is material.
Prior to 16. Yes, yes, yes. I am not objecting to that. Their case is that it cannot go prior to June 12, 2016. They are taking it to be 2019. So here your petition, when I will place the statute, then this fact will emerge whether it will be 29th April 2016 or whether it will be June 12, 2019
That's right.
for the commencing point. Now these are 1.11. Considering
And so far as your deeds are concerned, they
all
are
of 16, all of 16, except for 250, 2000.
some of them are post April 29. Like May 16,
My deeds are referred to.
yes.
My deeds are
April 28, this is the date prior. Except the first one, 3 dismissed, May 16, 2016.
yes, May 16.
That is post April 29, 2016.
Yes. But here it is 3 preceding years.
That's right,
That
3
I will-
preceding, if you take the date as April 29, then 3 preceding will be
19 will year. That I will be that. I keep
Okay.
it reserved for my argument.
Yes,
when I will
yes,
be arguing
sure.
on point of view. Now here 1.11. Considering Peter when he himself stated that several deeds were executed. So, in the case of Ghanshyam Das, Honorable Bombay High Court was pleased to hold that it is the duty of the person to appear before his due hand when considering the issue of due diligence as required, so it is important for the court to examine if the party has suppressed the information which is otherwise available in the public domain. The relevant portions of the judgments are introduced as well. Insofar as due diligence provisions as contained in under 4127 is concerned, for the same to be attractive, it will have to be demonstrated that in spite of due diligence, the evidence was not within the knowledge of the party seeking to produce the same. In this regard, a perusal of the content of the application under 4127 CPC dated 5917 demonstrate that knowledge in respect of the document in question was claimed to have been received by the defendant when he is said to have made search in the office of Sir Registrar and other places, whereupon the same deed was found, which indicated that plaintiff had no right remaining in the suit property. It was also contended that the said document is being executed by the plaintiff was intentionally suppressed by the plaintiff. The issue of due diligence has to be looked into within the background as to whether there was knowledge available in the public domain which could have been easily accessed by the party. It also has to be looked into from the angle of the duty of a party having knowledge about the additional evidence to disclose the same in the proceeding. It is necessary to state that it is bound duty of each and every party to the suit, whatever his status, whether plaintiff or defendant, to make full and candid disclosure of all relevant facts as well as document necessary for deciding the case before the court, and any suppression of any fact or document would clearly disinherit such party from the belief, claim or defense raised. The very basis of judicial inquiry and decision is a fair trial, free of suppression and filled with candid disclosure, which every party to the litigation is duty bound to make. Then small tracts visible, large tract of land. The total area for which it is of 84.80 acres The sale deeds marked as Exhibit 1 to Exhibit 1/15 are for much smaller tract of land. The Honorable Supreme Court in 2004 has held that when compensation is being determined using sale deeds with respect to small tracts of land, the court must ascertain if such transactions are genuine and reliable and the lands have comparable features. However, in the case at hand, the level court has failed to evaluate any issue before enhancing compensation from 8.23 to 11,000. Then comes interpretation of 26, the Act 2013. It is further submitted that even otherwise the deeds are admissible under law. The explanation 626 provides that the deeds for the 3 preceding years from the date of proposal of acquisitions are to be considered. So word used is proposal. In the case at hand, the proposal for acquisition was made in year 2016. The same would be evident from the case details of the land acquisition case, which is numbered as LA case number 1 of 2016-17. And as such, all deeds of 2015 and 16 can be considered. However, the cutoff date is from the date of notification under section. However, if the cutoff date is from the date of notification under section 11 of the Act, the same deed executed in the preceding 3 years, that is 18, 17, and 16, should be at least considered. The Act 2013 provides that the deeds from the 3 preceding years ought to be considered. The word year is not defined in the Act 13, and as such, definition is provided under the Process Act as 366. Yes, as the year means a year according to British calendar, the entire year must be considered. Given the fact in the hand, given the facts of the case at hand, the sale deed produced before this honorable court should not have been produced by the applicant even after due diligence, as the could not have been produced by the applicant even after due diligence, as plaintiff materially suppressed the same. The applicant only came to know about the same when the vendee's application for payment of annuity under rehabilitation scheme was being processed. Since the claimant themselves had sold land for an average price of 5,000 per decimal, the compensation determination by collector is just and accurate. So this is the background.
How do you say that these documents could not have been procured by you in spite of due diligence? Because these are all public documents. All the sale deeds are public documents.
No.
Whenever acquisition takes place, the first duty is to find out from the circle office what is the rate, which properties have been sold. From registry office, this is the information you get from the registry office.
There I have relied on the judgment that if the defendants were knowing this document, they are party to it, then they cannot suit these owners, saying that it was their incumbent duty to produce the same. That one judgment we have relied. I will refer to that. Number one. Number two, my interlocutory application may be seen, where I have sought under 4127. I have given the possible explanation. Their only denial is that, their only difference is that these are the deeds prior to 2016, 12 June 2016. That is what they say in their, nothing beyond that.
Prior to 12 to 2016.
Yes.
So they are taking the reference date as 12 June 2019.
19, exactly. They don't say that they, because they were the party to
So
this
therefore
document.
you cannot say, since they were, say their impression, we are also confused. So we can say that they were also confused. Then under such circumstances, just a moment.
Yes.
Then under such circumstances, they took the cutoff date as 12th of June 2019, and whatever was available for last 3 years, they had produced. Whatever was available. This is as per their own wisdom, whatever they have done. So you cannot say suppression. Once the day, what the court has taken the date as 12th of June 2019.
I just take a pause. Your Lordship, it would have been a case otherwise. Now they have produced two documents prior to that June 2016, that is April. Their document is of April 8, 2016 and April 3 or 13 of 2016.
That's right.
So they have produced the document before that 3 years.
They have produced whatever. But
No, they have produced, so they cannot say that we were very
all
candid
the
understanding.
documents, you see, all the documents, many of them
Vicinity village.
many of them after April 2016. Many of the deeds which have been produced by them, many of the deeds, you just see
No, those are-
2018, 2019,
Those are of vicinity village, not of Teresa.
maybe.
Now
Maybe
when
of.
Teresa is available, where is the question?
No, that's right. But you see, their conduct, that we are looking at their conduct.
Yes.
They have produced the sales till the year 2019 also.
Yes.
So, the very fact that they are producing the sales of 2019 may be of neighborhood village. So, it cannot be said that they had, they were aware that the cutoff date is April 29, 2016.
Two Teresa deeds are before that.
Maybe.
So
You
yes.
see the reason why did they produce the vicinity village? Because they were aware of the fact that there are two deeds of Teresa which is beyond the cutoff date.
I will
It
argue
is a
that-
natural conduct.
I will argue, no, it is not natural. These are two high value deeds, 25,000. Please take note of that. During it is 25,000 per decimal, 50,000 two decimals,
It is
50,000 two decimals. Page number 2 of my notes.
yes 25,000 per district.
So they are very cunningly they have produced these two dates of the
Cunning
same
is a
year.
very strong word. Cunning is a very strong word.
Yes. I will demonstrate from the record. My lord, ultimately we are going to pay from the state actually. So the law has taken a very, because once proposal comes,
See, whatever documents you have produced, irrespective of their intention, etc. These are the registered savings
yes,
executed by them, and apart from their objection with respect to the cutoff date, if we find that the cutoff date is 29th of April 2016 and not 12th of June 2019, then under such circumstances there cannot be any impediment in considering it.
which one?
But the core issue is what is the cutoff?
Yes, now come, my lord, kindly come.
Because their only objection is it is beyond 3 years from the cutoff date.
Yes.
If the cutoff date is June 12, 2019, then their objection is correct,
Yes.
right? And if the objection is 29 April 2016, then their objection is not correct.
So maybe we need to go through then section 26. Whether they should have the
That is it. ये स्टैम्प ड्यूटी ये 2013 एक्ट राइट टू पे कॉम्पेंसेशन
You have quoted this part. You should be kindly
we'll see it from the act itself.
Yes, that will give you a better impression.
जब आपके रिटन सबमिशन में इतना टाइपोग्राफिकल एरर है उसमें
एक
क्या
ही
क्या
है,
हुआ
पूरे एक ही है।
नहीं हम तो बहुत सारा करेक्शन कर लिए कोई बात इट्स ऑलवेज बेटर टू सी इट डायरेक्टली सेक्शन 26 राइट
Yes, yes.
Just a minute. Section 26. Yes.
The collector shall allot. The collector shall allot the following criteria in assessing and determining the market value of the land. Namely, 1. The market value, if any, is specified in the Stamp Act 1899 for registration of sale or agreement to sale as the case may be. So this is one exhibit that is on record.
This is the circle date.
Yes,
Circle date of the year
2020.
20.
So this cannot be ignored.
2020 means it is much beyond 2016.
Much beyond, so it will give a better rate.
Not necessarily.
Always.
No.
I will place the judgment.
No.
I will place the
We
judgment.
will not assume that with the passage of time the value of the land in every place is increasing. Assumption पे नहीं चलता.
नहीं वही सुप्रीम कोर्ट का जजमेंट जब हम प्लेस करेंगे तो उसमें आएगा जुडिशियल नोटिस ऑफ दिस so it always takes a positively, it never takes a negatively.
Not
Land.
necessarily. Not necessarily. You cannot say.
I cannot, I have in my career I have not gone through a single place which has shown a negative dip in the valuation. Government has to collect revenue. It will never
रियल
fix a
एस्टेट
rate.
का वैल्यू कैसे कैसे चेंज करता है, कैसे
गवर्नमेंट
क्या
अपने रेवेन्यू को कभी डिप्लीट नहीं करेगी उसको. जब भी ये सर्कल रेट मींस व्हाट फॉर द पर्पस ऑफ कलेक्टिंग
सर्कल
स्टैम्प
रेट.
ड्यूटी.
Circle rate is fixed on the basis of the various deeds which are
Yes.
available. Right? We have also seen deeds where the market value is less than the circle rate. आपने सुना नहीं है? बिहार में नहीं देखे आप? देखे कि नहीं देखे?
इसलिए है, इसलिए नीचे
इसीलिए है.
क्यों?
हम नहीं
गवर्नमेंट
जानते
अपना
क्यों.
सर्कल रेट को कभी कम नहीं करती
ठीक
है,
है, लेकिन
क्योंकि उसका रेवेन्यू मार्क कट जाएगा.
that's right. So you cannot say that circle rate
Is always above market value. Where government is one which is
सर्कल रेट. आपको सर्कल रेट में रांची में कोई जमीन मिलता है क्या?
उससे क्या
ऊपर ही मिलता है ना.
नहीं अभी एक्ट पे है. एक्ट मैंने भी है बाउंड बाय द लॉ.
Yes. That is the mandate of law.
Yes.
That circle rate has to be done.
That is a. Now ignoring a.
Or
Then comes
or.
The average sale price of similar type of land situated in the nearest village or nearest vicinity area.
तो nearest village भी ले सकते हैं.
ले सकते हो.
As a matter of fact. और है.
Yes.
Option.
Consented amount of compensation. This is not for our purpose as agreed in subsection 2 of Acquisition Act of land for private companies. Whichever is.
इन तीनों में मोड में से जो हाईएस्ट होगा वो आपको देना.
ये नहीं करना.
नहीं, of course. You see, there are
Consented
three
amount of
modes.
compensation.
There are three modes.
Compensation as agreed upon under section 2 of section 2 of case of acquisition of land for private companies or for public-private partnership project.
ये जो तीन और है ना,
हाँ.
इन तीनों में से
Whichever
जो
is
हाईएस्ट होगा आपको वो देना.
Whichever is higher.
तो तीनों का कैलकुलेशन होगा. तीनों का कैलकुलेशन में जो हाईएस्ट होगा आपको वो देना है. ठीक है.
तो अब हमारा यदि वन पॉइंट में भी ठीक है, यदि मेरा उस विलेज का है तो हम विसिनिटी में जाएंगे कि नहीं?
ऐसा जाना ही होगा एज पर द मैंडेट.
नहीं
है तो
माय सबमिशन वुड बी नो.
जस्ट आपका सबमिशन नहीं, पहले एक्ट का सबमिशन देखिए.
हां नहीं ठीक है.
Provided
that
you see the average sale price of similar type of land situated in the nearest village or nearest vicinity area.
ठीक है. Cut off will be important. Consented amount of compensation.
Explanation 1 पढ़िए पहले.
Yes.
ये पहले provided that.
Provided that the date of determination of market value shall be date of notification, date on which the notification has been issued under section 11.
So 12th June 2019.
Date of determination. Now explanation 1.
नहीं, date of provided that the date of determination of market value.
Market
value किस लिए determine करना है? For the payment of compensation.
Yes.
So the date of determination of market value shall be the date on which the notification has been issued under section.
Yes.
This is the cutoff date as per this determination of market value.
Yes. Now explanation.
Explanation 1.
The average sale price referred to in clause B shall be determined taking into account the sale deeds or the agreement to sale registered for similar type of area in near village or near vicinity area during immediately preceding 3 years of the year in which such acquisition of land is proposed to be made.
That's right.
So now proposal it is.
इसको देखिए, ऐसे नहीं है, हम लोग ऐसे सेग्रीगेट करके नहीं पढ़ेंगे. Determination of market value of land.
Yes.
And the date on which the market value is to be determined
Yes.
is the date of notification under section 11.
Yes.
Clearly provided. उसको अगर हम लोग इसके साथ पढ़ेंगे तो conflicting हो जाएगा.
नहीं conflict हो. Let me explain. It says A is available, A is not considered. B is not taking into consideration, so vicinity area how it has to be done. For B, explanation 1 is what is to be done. That 3 preceding year, if that meaning is given, then the whole object of explanation 1 will be defeated.
No.
So explanation 1 says the average sale price referred to in clause B.
You see, when we refer to section 11,
Yes.
it is still at the stage of proposal. Unless the final notification is issued, it is still at the stage of proposal. Because there may be numerous objections. There may be many objections.
May be objection. What legislative intent, if you legislatively go into it, it says that once proposal comes, then there is a natural surge in the price of the property. So that proposal date has been taken for the purpose of fixing the sale price, and 3 years back to that is taken. Because legislature has used the word notification under section 11 in proviso for determining market value, and then in explanation 1 it says
अगर मार्केट वैल्यू हम लोग को डेट ऑफ नोटिफिकेशन अंडर सेक्शन 11 में डिटरमाइन करना है तो उसके प्रीसीडिंग पीरियड का कोई भी चीज का क्या रेलेवेंस?
no material before the court.
That is a separate thing. We are on section 26.
Yes.
The cut-off date is June 12, 2019, as per section 26, and not April 29, 2016.
In my that I am trying to persuade with your question. Explanation 1 clearly says proposed. It does not say section 11 notification.
That's right.
So that is my summation.
You'll see that.
For yes. So in my humble submission, then it will be April 2016. That is the proposal.
You see section 11.
Yes, yes.
The area is required or likely to be required for any public purpose. तो यही proposal है.
Budget notification.
That's right.
So first, before budget, it comes section 4. If you will come, that says that it has.
Section 11.
Section 11 is preliminary notification. Before that exercise for proposal, that social impact assessment, everything has to be carried out. Then section 11 budget notification comes from.
Gazette notification for what purpose? You see section.
For acquisition, yes. For acquisition.
No, not where it appears to the appropriate government that the land in area is required or likely to be required for any public purpose. Or likely to be required for any public purpose. This is still at the stage of proposal. Is required or likely to be required for any public purpose. This is still at the stage of proposal.
The record will suggest that we have said that proposal was mooted on that date, that is, we have said April 29. Fresh application for initiation of land acquisition procedure.
No, you see,
that is 29th April 2016.
This particular document of fresh application, right? This is absolutely amongst the government authority.
This is proposal.
This is, you see, the NTPC is proposing that I want this land,
Yes,
or the state is proposing that I want this land,
Yes.
and they are writing letters to the government that yes, we require this land,
Yes.
right? Then there is some assessment and everything is done.
Yes.
Then the
Surveying is done.
then the government is satisfied. Yes, this land is required or may be required,
Yes, yes.
and then they issue a notification under section 11. That is also at the stage of proposal.
So, and law says proposal.
Yes,
When
so
we are
that is
taking
also at the
vicinity-
stage of proposal.
Then vicinity areas land when we take into consideration 3 year proceeding from the date of proposal. And proposal date is there 29th April 2016. My submission would be this one. In support of my contention. Now,
This proposal is given under which section? This cutoff, this date of 29th April 2016 is given under which section? There has to be a section. If you want to refer to 29th April 2016, it is under which section? बताइए कौन सा section में? It is referable to which section?
I am trying to understand this act.
We are also trying to
Yes.
understand this.
Now
And
it
this is under which
says,
section?
like proviso, when proviso comes, that provided that determination of shall be date on which the notification of sale is under section 11. Explanation 11. One never says that proposal has to be under a particular. Proposal is only a stage when we make a request that we need this land for this purpose. Then the things starts, because to protect the land brokers from entering into this realm of purchasing the property and escalating the price, so the proposal date is very relevant. It
It
goes
is
to
not like that. It
This
is
is
not
the-
like that. No, it is not like that. Everything starts with a preparation of a preliminary investigation and determination of social impact and public purpose. These are the basic elements which are required to be determined before the court, before the authorities say that yes, we need this property or this property may be required for a public purpose.
in my humble submission. Once I will make proposal, or else why the authority will go and
तब तो ये जो दिया ना मार्केट वैल्यू इस पर्टिकुलर डेट का डिटरमाइन होगा तो गलत है उसको आपको चैलेंज करके उसको स्ट्रक डाउन करना
नहीं इसको चैलेंज करने की जरूरत नहीं है, क्योंकि सर्कल रेट जो है ना, सर्कल रेट 19 का जाता है या 20 जो भी आएगा, वो सर्कल रेट अवेलेबल था, वो सर्कल रेट
तो आप-
whichever is higher ले जा रहे हैं, तो विसिनिटी लैंड का
सर्कल डेट आप 2019 का क्यों नहीं प्रोड्यूस किए?
वही फाइनेंशियल ईयर 2020 का है वो डेट।
2020 का अभी तो आप कैलेंडर ईयर की बात कर
चेंज नहीं हुआ था 2018 से।
कहाँ से बोल रहे हैं?
वो एग्जिबिट आई एम जस्ट प्रेसिंग दैट इट इज फॉर ए पीरियड एवरी ईयर दे डू चेंज इट it is exhibit B.
What is the date of issuance?
It is 28th of January 2020. Subject is it is writing. I am just pressing for consideration. हजारीबाग जिला अंतर्गत समस्त अंचलों के ग्रामों के मार्गदर्शिका पंजीकृत प्रश्न उपयुक्त विषय प्रासंगिक पत्र हजारीबाग जिला अंतर्गत समस्त अंचलों के अधीनस्थ पढ़ने वाले मौजों के भूखंडों का श्रेणीवार निर्धारित न्यूनतम मूल्य का सूची का मार्गदर्शिका पंजी पत्र के साथ संलग्न कर भेजा जाता है। संशोधित मूल्य दिनांक 1/11/2018 से प्रभावी है एवं बाजार दर का स्थानीय नहीं। ये हजारीबाग डिस्ट्रिक्ट अंचल केरलदारी डिस्प्लेस 30।
ये डॉक्यूमेंट हमको मिल नहीं है। This is letter dated?
This is letter dated 28th of January 2020.
28th
of January 2020 by the district sub registrar to the land acquisition office.
Exhibit B तो बस ऐसा ही है लेटर।
लेकिन उसके पहले हुआ है कि उसके बाद हुआ है।
28/2/20
28/1/2020
28/1 पर तो लेटर से 28/1 का
उसके नेक्स्ट पेज से चार्ट दिया हुआ
संशोधित मूल्य दिनांक 1/11/2018 से प्रभावी होगा।
नेक्स्ट पेज में सारा विलेज का डिटेल दिया
एंड एज पर द सर्कल डेट क्या डेट है?
सर्कल रेट में रेट यहाँ दिया हुआ कैरेसा का सीरियल नंबर 10 on the next page 39 industrial is 3930 agriculture is 2620 residential is 5240 serial number 10
तो तीनों में से तो जो हाईएस्ट है वही
वही दे दे
नहीं तो सर्कल डेट तो आपका कम ही है।
कम है
ठीक है आपने जो फिक्स किया था वो सर्कल डेट से कम में किया था कि ज्यादा में?
ज्यादा है 4823 हमने इसलिए किया कि बगल में विलेज में एक जगह थोड़ा ज्यादा पेमेंट होगा तो वी रीएडजस्टेड बिकॉज़ दिस इज आल्सो वन ऑफ द रिक्वायरमेंट दैट वी शुड मेंटेन parity amongst the various villages so that chaotic situation नहीं हो जाए कि कहीं
The acquisition was isolated with respect to this village or it was huge chunk was acquired? The acquisition was with respect to the huge chunk. Where is the notification under section 11? That is exhibit?
yes and actually
Exhibit? F.
that is letter dated 7/6 notification dated 7/6/2011 so this is only reflecting second line that is 84.80 acres and the village detail is given in this very particular document.
This is a notification under section 11(1) and yes. NTPC कोयले खनन परियोजना के ओवर डंपिंग प्रयोजनार्थ हजारीबाग जिले के केराडारी ब्लॉक के
रहसा में 85.06 एकड़
तो प्रस्तावित भूमि के कुल 247 प्लॉट है।
इस परियोजना में हितधारकों की आजीविका का प्रस्तावित अधिग्रहण से सकारात्मक प्रभाव पड़ेगा। परियोजना के क्रियान्वयन से समुदाय को नई रोजगार एवं आय का सृजन, वैकल्पिक आय का स्रोत, स्थानीय रोजगार की पड़ेगी, जिससे उनके आय में वृद्धि होगी, जिसका अनुकूल असर क्षेत्र में सामाजिक एवं आर्थिक विकास को पड़ेगा। परिणाम स्वरूप समाज के सभी वर्गों को लाभ प्राप्त होगा। योजना के संभाव्य फायदे सामाजिक खर्च और प्रतिकूल सामाजिक समाधानों की तुलना में बहुत अधिक है। प्रस्तावित भूमि याचना के लिए दी गई भूमि न्यूनतम है तथा इससे काम स्थापित किए जाने संबंधित कोई अन्य विकल्प उपलब्ध नहीं। परिवारों की संख्या 230 है। इस बाध्यकारी विस्थापन का कारण नीचे दिया गया है। Nature of the land is also defined, but we take for industrial also it will be what I want.
अच्छा, जो आपके सरकार ने जो एसेस किया था एक्विजिशन, वो कौन सा
एग्जिबिट डी? एग्जिबिट डी दर प्रतिवेदन after the tabular chart you will find the discussion of the rate. It has dealt with the vicinity rate every place. उपरोक्त दर प्रतिवेदन में
आप जरा देखिए, आपके ऑफिसर ने भी, स्टेट ने भी धारा 26(1) के स्पष्टीकरण 1 के अनुसार अधिसूचना की तिथि 12/6/2019 के ठीक पूर्ववर्ती 3 वर्षों के दौरान, अर्थात 12/6/2016 से 12/6/2019 तक निकटवर्ती, मतलब ये भी वही कट ऑफ डेट ले रहा है।
लेकिन हम लोग स्टैट्यूट को देखते
नहीं, स्टैट्यूट तो देखेंगे ना, लेकिन स्टैट्यूट इज वेरी क्लियर। आपका ऑफिसर भी वही कर रहा है, ठीक है, वो नहीं कर रहा है जो आप बोल रहे हैं।
स्टैट्यूट को तो बोलने का राइट है।
हाँ, स्टैट्यूट
स्टैट्यूट को होगा।
नहीं, स्टॉपल अगेंस्ट स्टैट्यूट नहीं होगा, स्टॉपल अगेंस्ट स्टैट्यूट नहीं होगा, लेकिन उसकी भी समझ में वही आ रहा है जो उसने किया है।
वो मान लेते तो आज तक तो ट्रैवल करता ही नहीं, कि समझदारी को ऐसे नहीं करना। माय स्मॉल सबमिशन।
ठीक,
ग्राम तेरेसा जब प्रतिवेदन you will receive, so it says that ग्राम तेरेसा के निकटतम ग्राम मनातू पांडु स्वयंसो तालुक में भूमि अर्जन पुनर्वास और पुनर्स्थापन के उचित प्राप्त और पारदर्शिता पर 2013 की धारा 26 के अनुसार दर करना नहीं। So it has taken into consideration to find everything केवल the decision भूमि every aspect has been taken.
और ये डिस्ट्रिक्ट लैंड एक्विजिशन बोल रहे हैं कि क्योंकि वहाँ का कोई है नहीं डीड अवेलेबल, इसीलिए
वो नहीं इसको ले रहे। तो अब ये जो कंपैरेटिव चार्ट दिए, दिस वाज नॉट डिनाइड बाय them, rather they have come with these deeds of vicinity. What they say,
they have come, you see the land acquisition officer has said that मतलब no deed is available for the same village.
same way.
This is what he has
What
said.
he says, yes.
Right, that no deed is available for the same village, and therefore they have come up with the deed of the same village and also deed of the vicinity villages. And so far as your deeds are concerned, those according to them are beyond the period of 3 years.
That's what he says. He also,
If we take the cutoff date as in of the year 2019, Then the deeds which you are seeking to adduce in additional evidence, those are beyond the 3 years if the date is taken into consideration instead of calendar.
Then one more interpretation which I am trying to advance before you. That is 2019, what it says, 3-year preceding. So if I take 2019, then what will be the meaning of year? So year has not been defined in this act, but general clauses act, that the question was also said, the calendar year, British calendar year, that is the 366.
That is not the intention of the
So
legislation.
that will be important because if 19 comes and they have also therefore
ऐसे
relied
नहीं
upon.
हो सकता है ना,
तो
ऐसे नहीं हो सकता है क्योंकि 1 जनवरी से लेके 31 दिसंबर तक द ईयर इज अ स्प्रेड. इतना वेग कोई स्टैट्यूट नहीं छोड़ा जा सकता.
So it will go to the extent means 2 months, the calculation will go,
डेट टू डेट,
it will go 3 times, 2
डेट
times,
टू डेट.
2 times.
डेट आपका कौन सा डेट आपको
मेरा
पता
पहले
है?
तो सर्कल रेट है,
नहीं, एक सेकेंड. जो आपका सर्कल रेट है,
हाँ,
that is one parameter.
one parameter, second
The
parameter.
second parameter is the
Vicinity.
deeds.
Yes,
Okay, second parameter में deeds है, which are there of the village
yes,
or in the vicinity.
yes.
सबका एवरेज लेना है, ठीक है. एवरेज लेकर उसमें 3 साल कंसिडर करना है फ्रॉम डेट टू डेट, यानी 12 जून 2019
Date
से
to date
लेकर.
नहीं, date to date नहीं.
कोई बात नहीं, कुछ तो हम लोग तो कुछ करेंगे ना. स्टैट्यूट है, कुछ क्लैरिटी नहीं है तो हम लोग कुछ तो
Clarity
करेंगे.
है. तो
कोई
जनरल
clarity.
क्लॉजेस एक्ट इसलिए रेस्क्यू में आता
ऐसे
है.
नहीं आता है जनरल क्लॉजेस एक्ट का इंटरप्रिटेशन इस
अभी
तरह
तो
से.
कोई ऐसे ही अब जहाँ पे नहीं एक्ट डिफाइन करता है तो वी फॉल बैक टू दैट इज व्हाट जनरल क्लॉजेस
तब तो
एक्ट.
लिमिटेशन भी चलेगा ईयर टू ईयर.
नहीं का है उसमें लिखा हुआ है 30 डेज 90 डेज, उसमें ईयर नहीं लिखता है. आफ्टर 2 इयर्स
3 इयर्स नहीं लिखा है कहीं.
3 इयर्स लिखा है, तो 3 इयर्स में
3 इयर्स में तो साल हो गया. अगर 1 जनवरी से कॉज ऑफ एक्शन हो गया तो 3 साल बाद उस 3 साल थर्ड ईयर का
from the
31
date of
दिसंबर.
judgment, from the date of judgment, if you reckoning date is also there.
नहीं, वो नहीं बोल.
हम लिमिटेशन का
एक
बोल
सेकंड,
रहे
एक
हैं.
सेकंड.
यस यस.
लिमिटेशन में अगर कॉज ऑफ एक्शन से 3 इयर्स में हमको करना है
हाँ.
सूट, अगर 1 जनवरी को कॉज ऑफ एक्शन हो गया है तो 3 इयर्स बाद तो 1 जनवरी को और 3 इयर्स खत्म हो जाएगा. तो आपका कहना है कि 31 दिसंबर तक सूट फाइल हो सकता
नहीं
है.
नहीं नहीं, कॉज ऑफ एक्शन डेट है. कॉज ऑफ एक्शन ईयर नहीं होता है. कॉज ऑफ एक्शन इज ऑलवेज a date.
इसीलिए
Here it is not a cause of action. It is saying that 3 preceding year because it is trying to arrive at a just figure, not in such a precision. It is not looking into it. Or else the legislature would have marked. Now limitation जब भी बोलते हैं हम वहाँ पे cause of action बोलते हैं. जब भी when I came to knowledge of it, I have to give a declaration. A date has to be given. I will not say that in the first century or first year I had come to this knowledge.
does not appear to be correct interpretation.
My summation.
As per my understanding.
Yes, but
हम तो
limitation.
date to date ही
In
लेंगे.
my humble summation, limitation analogy will not help me
नहीं,
because limitation is always dependent on cause of action, and cause of action is always a date. Now, my lord, so I take it that 19 means 16 has to come, and that is how they understood. That is how
the
Teresa.
first of that they understood is immaterial. What the law understands is material. Right?
You just said me that my officer understood. So I am.
No, your officer, I'm it's just an observation.
Yes.
That this is how your officer has also
Yes,
understood.
he has understood.
Right?
I
He has
cannot-
understood
I
it
cannot
and he has
wriggle out of
taken
it.
the date from date to date 3
Correct,
years.
correct. I cannot wriggle out. He has taken it. Now, entire evaluation you already see, a competent expert body has dealt with. From this exhibit, the valuation report of this, he has dealt with what nature of land, everything, vicinity, village, he has dealt with everything. Now, the referral court has not dealt with this aspect. He has only taken the exhibit of 15 sale deeds of the vicinity village, then he comes to a figure of 15,000.
आप ही बताइए, आपकी उसमें जो रिपोर्ट है उसमें क्या डिटेल दिया हुआ है, कौन सा सेल डीड कंसीडर किए हैं, कौन कौन सा किए हैं, क्या वैल्यू है, कितना एरिया है, ये सब डिटेल है उसमें.
इसमें ना हाँ पूरा दिया हुआ है, एरिया वाइज दिया हुआ है, टेबल चार्ट में देखा जाए एरिया भी है. लेकिन उसमें एरिया भी है ना, डिस्प्ले रकबा, द फिफ्थ कॉलम रेफर्स टू द रकबा. यहाँ पे दिखा है. Yes. You should find area, valuation, everything has been written. Nature of land. the first column में भी सेम है।
तरेसा कोई विक्रय नहीं
नहीं है, वो तो अंडरस्टूड
नहीं।
है, वो तो बोल रहा है कि मेरे पास नहीं
ठीक
डिटेल
है, नहीं है। उसके बाद पहला वाला
मनातू में नहीं है, पांडु में नहीं है।
हाँ,
आप
उसके बाद
देखिए बेंगवारी में है,
2017 का।
अब उसमें देखिए रकबा 48 है डिस्टेंस
हाँ,
और 4,90,000 का क्रय वैल्यू।
तो ये वाला डीड इसमें नहीं है कंसिडर।
इसमें नहीं है, लोग अपना डीड जो लाए 15 बस केवल वही कंसीडर किया।
आपने कोई डीड फाइल किया था?
मेरा ये एग्जिबिट विदाउट ऑब्जेक्शन माना, दे आर नॉट चैलेंज दिस और दे ओनली से दैट
They have not challenged it. Does it mean that they have not challenged the contents also? ये जो आप इसमें डीड को जो आप रेफर कर रहे हैं,
जी,
तो
जी।
आपका काम नहीं है इसको वहाँ एग्जिबिट
मेरा
करना।
रिकॉर्ड का पार्ट है।
कहाँ रिकॉर्ड का पार्ट है? यहाँ पर नहीं है।
इसमें
It is not here. The deeds are not a part of this report.
सर
The deeds are not a part of this report. Deeds are not there before us.
दिस इज द
ये sacrosanct थोड़ी मान लेंगे आपका।
नहीं मान, तो व्हाट इज द बेसिस?
So was it not the duty of the state or you to bring these deeds on record so that these also be considered? भाई compensation तो देना ही है, इसके साथ ये भी कंसिडर करने का तो प्रेयर होना चाहिए था ना आपका। आपने तो कोई भी डीड नहीं प्रोड्यूस किया। Your report cannot be taken as a gospel truth merely because it has
When
been
sir,
sent without.
you receive report if the person comes and get it marked as an exhibit.
ये
Then-
छदम बिक्री क्या होता है?
Forced transaction. After this, that is what is being said. Which escalate the छदम बिक्री धारा 26(1) के स्पष्टीकरण 4 के अनुसार।
छदम बिक्री क्यों लिखते हैं इसमें?
इसलिए कि after the proposal came into picture, then this sale started effectuated by them. Section 26
तो
says
इसका मतलब इस डीड को भी नहीं डिलाई कर रहे हैं क्या?
नहीं हम ला दिए सारा रिकॉर्ड पे।
हम ये नहीं बोल रहे हैं। ये बताइए, ये जो बैंगवरी एंड बलिया, ठीक है, इन दोनों डीड के साथ में अभियुक्ति में मे बी कमेंट्स में छदम बिक्री लिखा हुआ है।
ये जो कंसीडर किए हैं टेबल के में सारी चीज डिस्कस कर दी
राइट हैंड साइड में छदम बिक्री दिया।
Yes, yes, that is related. But what he has considered, that is, the finding is there below the table chart. Details are there. Here it is. He has. If I place this to parallel, finding.
इसको रिजेक्ट कर दिया।
कंसीडर ही नहीं, तो 15 का केवल बेसिस ले लिया।
नहीं, ये दोनों डीड्स को नहीं कंसीडर किया है। 2017 के डीड को नहीं कंसीडर किया है, 2019 के डीड को नहीं कंसीडर किया। ये दोनों डीड को नहीं करते। छदम बिक्री बोल के इसको हटा दिया, इसको नहीं कंसीडर करेंगे। दिस इज व्हाट दे हैव डन। आप देखिए, यहाँ लिखे हैं कि उक्त आलोक में उक्त बिक्री विलेय छदम खरीद बिक्री को जो बाजार मूल्य का सूचक प्रतीत नहीं होता है, को त्याग किया जाता है।
इसलिए कि अब ये जमीन जो है 2019 वाला जो है वो देखना होगा इसमें कि 19 deeds were there before this notification or after.
डीड का डेट भी नहीं है, तो बिफोर आफ्टर आप कहाँ से पता करिएगा? एग्जिबिट ही नहीं हुआ, नॉट एग्जिबिटेड।
रिपोर्ट आया था लैंड
रिपोर्ट में कहाँ डेट लिखा है? आप कहाँ से एग्जामिन करेंगे उसको? फ्रॉम वेयर विल यू एग्जामिन इट? सम ऑफ द डीड्स हैव बीन रिजेक्टेड बाय सेइंग दैट इट इज व्हाट डू यू से, छदम को क्या बोलेंगे?
suspicious. Not fair.
नॉट पे,
Suspicious.
ओवर वैल्यू।
No, sir. छदम
ओवर छदम मतलब इसके लिए तो ओवर वैल्यू
ये
है।
हो जाएगा, but conceptually it will be that to defeat.
जो भी इनके फेवर का डीड था आप उसको सीधा उठा कर फेंक दिए।
नहीं, फेवर वाले भी डीड में आप देखिएगा एवरेज जाने से 6-7 हज़ार से ज़्यादा नहीं जाएगा।
कोई बात नहीं।
I'm just looking my.
अब हमारे पास जो डीड है हम वही देखेंगे ना, ये सब डीड ही हमारे पास नहीं है, तो हम लोग क्या देखेंगे?
लेकिन रिपोर्ट है आपके पास।
रिपोर्ट
और
से क्या
circle
होगा?
rate है।
रिपोर्ट सर्कल रेट है,
Circle
रिपोर्ट
rate
नहीं
है।
है। बस सर्कल रेट से अगर मान लीजिए एवरेज ज्यादा होता है तो सर्कल रेट का कोई वैल्यू नहीं है, बिकॉज और है ना।
अब ये जो तरहेजा का ये हम ईयर वाइज लेके तो 2016 तक आएगा।
देखिए, आप हमको आपका आर्गुमेंट हम नोट कर लिए,
Yes, yes, yes.
लेकिन आप हमको सीधा सीधी इस पीरियड का बता दीजिए। 12/6/2016 से लेकर 12/6/2019 तक का कौन कौन सा डीड है। इस डीड में भी आप मुझे वो बताइए जो इस विलेज का है और जो नियर बाई विलेज का।
मेरा एडिशनल डॉक्यूमेंट क्लियरमेंट का सारा डील 12/6/16 से पहले का
ठीक
है।
ठीक है।
और जो एग्जीक्यूटिव डॉक्यूमेंट है ये,
हाँ
उस डॉक्यूमेंट में इनका जो तरेसा का है वो डील वो पहले का है, बाद बाकी सारा डील इनका जो है आफ्टर 12/6/16 का।
तो ये तेरेसा का डीड तो कंसिडर हो ही नहीं सकता है। दोनों
दोनों इनका कंसीडर नहीं है।
नहीं हो सकता है क्योंकि
ये यदि वो बात रखा जाएगा
हाँ ऑफ कोर्स, तो ये दोनों तो कंसिडर नहीं हो सकता है तेरेसे का। ठीक है। अब बचा February 9, 2016, ये भी नहीं कंसिडर हो सकता है। जुलाई 25, 2015 ये भी नहीं कंसिडर हो सकता है। February 9, 2016 नहीं कंसिडर होगा। February 9, 2016 नहीं होगा। January 28, 2016 नहीं कंसिडर होगा।
ये आप पेज नंबर 2 पे आइए जो एग्जीक्यूटिव डॉक्यूमेंट।
हाँ हाँ एग्जिबिटेड, सॉरी ये April 20
पहला दोनों नहीं कंसीडर
नहीं होगा।
बाद बाकी इनका सब है 17 और 18। बाद बाकी सारा डॉक्यूमेंट का 17 और 18।
इसी का एवरेज कर लिया होगा उन्होंने।
नहीं, ऊपर का 8 का किया एवरेज
और बाकी
जो बोल्ड किया हुआ है 1/7
हाँ
एंड 1/10।
हाँ और बाकी
बाकी ये इग्नोर करके
बाकी क्यों इग्नोर किया, कोई रीजन है?
नहीं, वो दे दिए कि हम टॉप 8 डेट्स को हम लोग ले लेंगे।
ऐसा कोई टॉप 8 बोल के कोई है क्या? इज देयर एनी लॉ?
50%।
कहाँ है 50%? बताइए।
Yes, yes.
Yes, half. 26.
Explanation 2 में for determining the average sale price referred to in the explanation, 1/2 of the total number of sale deeds or agreement to sale
अच्छा।
which the highest sale price has been mentioned shall be taken.
तो ये टोटल नंबर कितने हैं? 15।
15
में तो 2 तो एक्सक्लूडेड, 16 है, 2 एक्सक्लूड हो गया, 14 बचा। 14 में से 7 कंसिडर करें।
8 कंसीडर हुआ है।
14 में से 8
नहीं,
कैसे
वो
कंसिडर
कंसीडर
किए?
किए हैं 8।
नहीं
जजमेंट में जो लिखा है यार
गलत किए ना भाई, 7 कंसिडर होंगे जो हाईएस्ट वैल्यू के होंगे। ठीक है, तो कौन कौन से होंगे बता दीजिए आप। 1/2,
1/2, 1/3,
1/3,
1/7 तक तो होगा क्योंकि उसी
1/7 तक तो होगा,
फिर 1/10 भी होगा।
1/10 होगा।
उसके बाद
हो तो गए 7, 1 2 3 4 5 6 7, यही तो है। पहला दोनों कंसिडर नहीं होगा, बाकी जो बचेगा 14 में से 7 कंसिडर होगा, उसका एवरेज लिया। आप क्या चीज के लिए फाइल करती हैं? आप लोग क्या चीज के लिए अपील फाइल की?
हम लोग किए ये कि वो उन्होंने 11,000 हमारा नाश करके दिया जबकि वो 15,000 होना चाहिए।
ये कैलकुलेशन गलत है।
हाँ, कैलकुलेशन में नहीं, कैलकुलेशन में उन्होंने 15,000 किया लेकिन विदाउट रीजन वो 11,000।
अच्छा, मतलब
हाँ।
जब एक बार स्टैट्यूट में प्रोवाइडेड है कि एवरेज लेके करना है
हाँ।
तो उनको वही करना है,
वही कर
वो फिर अपना बेस्ट जजमेंट नहीं अप्लाई कर सकते, यही ना?
नहीं उन्होंने जो किया
जब एक कैलकुलेशन किया तो उसके अलावा वो लोअर रेट नहीं दे सकते। कैलकुलेशन किया तो उनको उतना ही देना।
देना है। प्रोसेस का एक बहुत बढ़िया जजमेंट है।
मेरा जजमेंट
हाँ।
मेरे सामने पूरे बढ़िया था, उसका क्या करें?
इसका सारा 26 और 27 पढ़ा जाए, बस यही इसी से कवर्ड है, खाली 26 27
उनको भी दीजिए भाई। याद है हमको।
हाँ, बस यही ये भी यही केस।
कंक्लूडेड। हाँ बताइए, अभी इनको करें, हम समझ गए आप क्या करें। जजमेंट पेश कर लीजिए, आपको जो जो जजमेंट पेश करना। और इनका एनहांसमेंट का भी रीजन को आप थोड़ा सा देखिए। वो सिंधु का बहुत देर से खोज रहे हैं। फर्क नहीं पड़ता।
It is too hard.
गर्मी लग रही है, इनको गर्मी लग रही है इनको।
एवरीबडी स्पीक्स आउटसाइड कि एसी बंद रहता है यहाँ, यू डोंट नो व्हाई।
ऐसे चल
नहीं चल रही, टेम्परेचर इज नॉट लेस देन 28 डिग्री। पोजीशन इज फ्रॉम 23rd November 23।
बताइए कौन कौन सा आपको प्लेस करना है। ये देखिए पुराने एक्ट से नहीं गवर्न हुए हैं, पुराने एक्ट का जजमेंट सब जो आप लगा रहे हैं
पुराने एक्ट का जजमेंट हम भी नहीं 20 ये
क्योंकि पुराने एक्ट का पैरामीटर
अलग है,
सिस्टम
ये
बिल्कुल ही अलग है,
बिल्कुल
इसलिए पुराने एक्ट का कोई जजमेंट आप मत मिलाइए, नया एक्ट का जजमेंट है तो
नहीं नहीं, हम अपना जो डॉक्यूमेंट एडिशनल डॉक्यूमेंट के लिए 4127 के लिए उसमें मेरा ये कहना है कि my case is very defined space that it will be 2016's deed will be valid. Plaintiff himself was a party to those deeds, he should have produced those deeds. He has not produced those deeds. Number one. Number two, that circle rate ought to have been applied. No reason has been assigned for this.
circle rate, we will consider the circle rate in
Third,
first appeal.
my authority had decided the valuation based on the parameters that nature of the land and every other aspect has been taken into consideration. Nothing has been dealt by the
नेचर ऑफ द लैंड कहाँ कंसिडर की, खाली रेट कंसिडर की, जो सेल डीड्स था
नहीं, उसमें लिखा हुआ है ना एग्रीकल्चरल टार्ड ये सब
दैट्स
defined
राइट,
है।
जो डीड्स था
हाँ।
इसमें कुछ डीड्स को रिजेक्ट कर दिए हैं, कुछ डीड्स को कंसिडर कर दिए
So if 2016
और सबको सेम रेट दिए हैं कि सबको अलग अलग रेट दिए
नहीं सब रेट
रेट एक ही है, तो नेचर ऑफ लैंड का कंसिडरेशन वैसे ही एक्सक्लूडेड है।
तो तेरे
अगर आप सारे के सारे लैंड को एक जैसा ट्रीट कर देते हैं तो नेचर ऑफ लैंड का क्लासिफिकेशन बाइफर्केशन का कोई रेलेवेंस नहीं।
my point is that तेरेसा का सर्कल रेट अवेलेबल था,
कितना
तेरेसा
था
का
कितना था कितना था
सर्कल रेट वो साइड में 5000 समथिंग था, वो एग्जिबिट एफ जो एग्जिबिट डी जो जिसमें तेरेसा सीरियल नंबर 10 में व्हिच आई प्लेस्ड
हाँ
दैट हाईएस्ट विल बी रेजिडेंशियल जो है उनका 5000 समथिंग। सो 26 20 अभी हाईएस्ट पॉइंट पी पकड़े हम लोग 5000
और दिया कितना है
दिया है 11,000।
नहीं उस अथॉरिटी ने कितना
अथॉरिटी ने तो 2620 एग्रीकल्चरल लैंड का इंडस्ट्रियल लैंड का कुछ एक रेट है लेस देन 34,000 एंड रेजिडेंशियल का है
हाईएस्ट पकड़िए ना, रेजिडेंशियल का क्या रेट दिया
5,000
5,000
240 है, कमर्शियल है 7,860
7,000
860
860 कमर्शियल।
यस, तो जब तेरेसा का ये अवेलेबल है तो देयर वाज नो ओकेजन टू लुक इनटू द विसिनिटी।
जस्ट ये कमर्शियल रेट है 7,860 और अथॉरिटी ने दिया कितना था
4,823
4,823 और लॉ ये नहीं कह रहा है कि सर्कल रेट अवेलेबल होगा तो बाकी सब एक्सक्लूडेड हो जाएगा। लॉ ये बोल रहा है कि सर्कल रेट अवेलेबल होगा और डीड्स अवेलेबल होंगे और जो भी क्राइटेरिया है और एंड व्हिचएवर इज हाईएस्ट if upon calculation of average as per the act the deeds are more beneficial then under such circumstances the deeds would prevail। अब आप सर्कल रेट में हमको कैसे लेके आइएगा बताइए, गलत जजमेंट नहीं कराइए, गलत जजमेंट कराने से आपको कोई बेनिफिट नहीं होने वाला।
नहीं जजमेंट हम कैसे जजमेंट तो आप गलत करेंगे नहीं, जो करेंगे वो जस्टिस
ऐसा नहीं है।
See, am I commanding that judgment?
नहीं।
I will never ask
You
you
see,
whatever
we
will
pass-
fall from your
You
decision.
see,
It will be
the
justice.
whole purpose of hearing you enough is to ensure कि कैसा कोई ऐसा तो नहीं पॉइंट है जो आप कहते कहते सबसे लास्ट में कहते जो क्लिक कर जाए, इसीलिए आपको इतना खंगाल रहा है। एक्ट में बहुत क्लियर है
Act clear है।
और है,
हाँ,
ठीक है।
जी।
ऐसा नहीं है कि सेम विलेज का अगर डीड नहीं है तो बाहर के विलेज का कंसिडर नहीं किया जा सकता है। ऐसा भी नहीं है कि जो विलेजेस हैं वो इस विसिनिटी में नहीं है। That is not your case. तो आपका एक कट ऑफ डेट पर है, दूसरा एक ईयर पर है, एडिशनल एविडेंस आपका ईयर पर बेस्ड, और वैसे आप बोल रहे हैं कट ऑफ डेट 2016 आप पकड़ा जाए, यही है।
नहीं, and this aspect is coming to the conclusion. Valuation report आप देखेंगे तो it has taken into consideration every aspect, क्या क्या वो materials consider करें, but most importantly कि how the things then will be worked out, the referral code, how it has judgment का थोड़ा सा part if I place it. Para 19 onwards.
कौन सा judgment? Impugn.
Finding is starts from para 15. That will be internal page 60.
Para 15.
Yes. Internal page 60.
Yes.
Heard the arguments of both sides. In the light of argument, reviews the entire material evidence which I find PW1 is Ram Swarup Puja. He is also the applicant in any case in his cross-examination and analysis. He has stated that the compensations for the acquired land was fixed by the government for 4823. The land was acquired in the year 2019. The rate fixed by the government was based on the government rate of purchase and sale of land at that time. At para 48, he has stated that he had given compensation at the said rate, but he had demanded 20,000 per decimal. PW2 is Manoj Kumar Oja. He is also the applicant. In his cross-examination, he has stated that land was acquired by the government in the year 19, and at the same time, the government rate of the land at Teresa village was 20,000 per decimal, but he has not filed the paper of fixed government rate in the court. At para 39, he has stated that some money has already been taken from the government for the land for which the case has been closed to increase the rate. At para 48, he has stated that the land has been acquired is of both residential and agricultural type. Type PW3 is the Pankaj Kumar Lalweswar in his cross-examination. At para 15, he has stated that he has purchased the land in the village Teresa at the rate 25,000 per decimal, and he can file the deed of the land. The nature of the land acquired in village Teresa is Star 1 and not residential. I find that 16 civils have been proved on behalf of the petitioner. After this exhibit, I further find that 5 documents have been proved on behalf of the opposing party. Exhibit A is the attested copy of the order sheet of LA case 1 of 1670. This will be important for the purpose of disciplining proposal. 19 is 11 notification. LA case is of 2016-17. Is a attested copy of the sale figure chart. Exhibit C is the attested copy of estimate. Exhibit E is the attested copy of rate report. Exhibit E is the attested copy of valuation Khatiyan, and Exhibit F is the attested copy of the notification number 562. In all the sale deeds filed by the petition except land sale deed number 1/2 and 1/3, type of land is residential. The land of Exhibit 1/2 and 1/3 are agricultural type, which is of village Jamira adjacent to village Teresa. The rate of the land of Exhibit 1/2 is rupees 33,794 per decimal, and rate of land exhibit 1 by P is 16,581. It also appears from the evidence of the witness of the petitioner that claimants have been paid compensation at the rate 4823.95 per decimal. I further find that rate report exhibit E submitted by PP shows that there is no sale transaction of village terrace. Furthermore, all the sale deeds except 2 sale deeds are residential nature. Therefore, the rate of those sale deeds should be converted into agricultural nature. The exhibit D filed by the opposite party itself shows that how the rate of land can be fixed in residential to agriculture. As per these process shows that exhibit D, all residential rate of exhibited sale deeds should be converted into agriculture as half of the residential. In the case of seeing in a company, honorable court observed that market value cannot be determined on basis of circuit rate fixed per character under 348 of the stamp duties. So this will not be an accepted merit in the changed circumstances of the statute. Then AI 2004 Krishi Utpadan Mandi Samiti, wherein it has been held so and so that the market value under 23 of land acre cannot be fixed on the basis of valuation register. 1994 again same principle he has discussed in para 18. I further find that for determination of market value of land is essential to go through the provisions of section 26B of right to fair compensation. It is as follows: the average sale price for similar type of situated in the nearest village or nearest vicinity area. Explanation 2 of right of fair compensation and transparency in land acquisition, rehabilitation and settlement. For determining the average sale price, referred to in explanation, 1/2 of the total number of the sale deeds or agreement to sale in which highest sale price has been mentioned shall be taken into consideration. I further find that 16 sale deeds have been executed in this case by learned counsel appearing on behalf of the petitioner. Calculation average submitted by learned counsel for the petitioner 1/2 of the total number of sale deeds in which highest sale price has been mentioned comes to 15,372 for the per decimal in the street. But from the community of perusal of valuation chart based on sale deed near in the adjacent village placed by the as well as valuation prepared by the land acquisition authority on the vicinity area adjacent to Teresa or itself based on circle rate, I come to the conclusion based on the fact evidence in the present case as well as the settled law with regard to the guiding factor towards the assessment of valuation. It is just for the interest of justice that 11,000 per decimal is assessed for compensation to the entire land situated in Maja Teresa, which has been acquired for the 20% period related to the present case. Hence, all the petitioners are entitled to get compensation at 11,000 per decimal, and are also entitled to get all the statutory benefit provided under the provisions of Act 2013, the payment of compensation no benefit. Non-benefit shall be given in this month's 48 of the law. This is the finding of the court. Now to sum up my argument with it, for my additional document, as I have already placed in the written note, those judgments are there. My only submission will be that 2016 date cannot be ignored. And
from where do I get that? What is the nature of the land acquired?
see, in my this land, 84 point.
Because flat rate was taken by the authority. Flat rate has been taken by the court also. Is there any document to say that what is the nature of the land
Yes.
acquired?
If I just take your attention to exhibit F.
Exhibit F.
It is the notification.
Yes.
Exhibit F में जो भूमि का प्रकार लिखा हुआ है the
सब
court,
टाट थ्री है entirely.
yes, and the court has also taken this to be agriculture when it says that 50% of the residential area.
Yes.
So the court has also taken it to be agriculture, and that is what is the Bhumika Prakar also. And notification, and this notification, budget notification under section 11. Yes. That last paragraph और चूंकि झारखंड राज्यपाल की राय में उनकी भूमि बंजर कृषि योग्य है, दस करके तो कृषि उनका तुरंत भोजन आवश्यक है, इसलिए उक्त अधिनियम के धारा 17 को
वो भी फ्लैट रेट में किया है, लेकिन उसने जो है रेजिडेंशियल का आधा करके
एग्रीकल्चर मान करके
एग्रीकल्चरल
इट इज नॉट प्रिसाइजली आधा, यानी जो एग्रीकल्चर थोड़ा ज्यादा हो रेजिडेंशियल से, रेजिडेंशियल 5200 कुछ है, एग्रीकल्चर 3900 वैल्यूएशन। ये सर्कल रेट में आप देखिए सीरियल नंबर 10 पे एग्रीकल्चर 2620 नहीं, ठीक है, एग्जैक्टली इट इज आधा,
एकदम आधा ही,
एकदम
वही प्रोपोर्शनेट लेकर इसको पूरा प्रॉपर्टी को रेजिडेंशियल का आधा लिया है और उसको कैलकुलेट कर,
सो ऑल बेनिफिट्स
लेकिन एवरेज दिया है 16 सेंटीज, 16 का एवरेज दिया है इम्प्यून ऑर्डर में।
हाँ, इम्प्यून ऑर्डर में
16 का एवरेज दिया है, जबकि लेना था हमको 7 का एवरेज,
नहीं 8 का एवरेज,
7, क्योंकि 2 तो एक्सक्लूडेड है, 2 तो एक्सक्लूडेड है,
वो एक्सक्लूडेड है ना, तो 14 में 7 लेना था,
सात
लेकिन वो लिए हैं 8 का,
नहीं लिए है 16 का,
8 का
ऑर्डर में 8
का ही है,
ऑर्डर था 7।
कहाँ लिखा है बताइए, तो 8 का
पैरा
नहीं है।
19 में of the interim order that is in the internal page 66.
16 salaries have been executed.
Calculation average rate provision submitted 11,000.
1/2 of the total number of salaries comes to
15,000.
15,000 ऐसे करके।
The whole things remain that whichever is higher, that is there, cannot be disputed. But then because first it starts with the stamp duty, then it says that vicinity area, or now vicinity area when the RESA is having previous rate, suppose for but circle rate was there, then whether there was any opposition to then go into this specific at least circle rate of those lands to have been brought by them, because that is the requirement that one should be fair.
सर्कल रेट तो आप डाली हैं,
हम अपने RESA कर दें, वहाँ का रेट वो inflated rate कितना vicinity है, हमने भी जो कैलकुलेशन दिया, they have not denied that these are not vicinity land, these are also vicinity land which
तो
have
you have excluded many of the salaries. क्या रीजन है? कुछ नहीं रीजन दिया, क्यों आप एक्सक्लूड कर रहे हैं उसको?
तो ये डिमांड होगा,
डिमांड क्यों होगा? डिमांड नहीं होता है,
मैं तो वहाँ पे
डिमांड करने का कोई काम नहीं।
My submission, that is the only point that I am raising, that 16 deeds or to have been issued have been fair, और इतना गैप नहीं हो सकता।
लेकिन डीड में तो वही है ना,
डीड में तो 4 डिसमिल 10 डिसमिल कर करके स्मॉलर वैल्यूज डीड को लाके सामने रख देते हैं। They have just escalated.
इसीलिए ये स्मॉलर वैल्यूज का डीड रहता है, इसीलिए ये एवरेज का प्रोविजन है, इसीलिए ये एवरेज, इसीलिए सारे को नहीं लेना है। तो दिस इज द मैंडेट ऑफ लॉ, इसमें कुछ कर नहीं सकते। आपको नहीं पसंद है तो छोड़ दीजिए, चलिए, दिस कैन हैपन।
Yes.
If you do not want, you can leave the land. That possibility is also always there.
The smaller piece of land में क्या होता है कि आदमी there are several.
ऐसा कोई स्मॉलर एंड बिगर पीस का कोई डिस्टिंक्शन एक्ट में नहीं है।
But 2022
और जो है उसी में इससे ना डिसाइड होगा,
हाँ तो बस वही 60
जो है उसी में डिसाइड होगा, जो नहीं है वो कहाँ से लेके आएंगे कि पूरा गांव का एक सैलरी कहाँ से लेके आएंगे?
लेकिन वो एडिशनल डॉक्यूमेंट विल हैव ए वाइटल रोल इन बाय सबमिशन।
ठीक,
So 41 2070 accordingly I am placing that also
You are president. You will take care of that. हाँ मैं आप बताइए क्या बोलना है?
ये आइए जो मैंने फाइल किया उसका जवाब
वो तो आपने बता दिया ना 12/6/2016 के पहले का, यही एक जवाब हो गया। अब इसका ये एवरेज कैलकुलेशन जो आपने फाइल किया है, ये जो कैलकुलेशन है, ये 8वां डीड कौन सा लिया है इन्होंने कंसिडर किया है?
हमने जो
8वां डीड कौन सा कंसिडर किया? करना तो 7 ही था। 8 डीड कौन सा है जो कंसिडर किया?
पहला जो 7 बेस्ट है
वो तो ठीक है, 8वां डीड कौन सा कंसिडर किया कोर्ट ने?
वन बाय वन
एग्जिबिट 1 by 1 कंसिडर किया है, ये तो कंसिडर हो ही नहीं सकता था। अब 7 डीड का आप एवरेज बता दीजिए कितना?
हम ये जो हम सबसे फाइल किए जहाँ से एक्स पर द एक्सपीड सेंडिक्स उसमें रीजन के साथ
बताइए आपका एवरेज कैलकुलेशन कहाँ है?
ये इसी में पॉइंट वाइज करके दिया हुआ पेज 6 पेज 6 एज पर द एक्सपेक्टेड सेंडिक्स। उसके बाद ये
देखिए पेज नंबर
पेज नंबर 7
ठीक है, आप फिर 8 का ही ले गए।
हम लिए हैं, दोनों लिए हैं।
अच्छा
8 में वो है और
7 में कितना हो रहा है आपको?
7 में हो रहा 15,782। The total average market value of
15,782 तो उनका 8 सेल डीड लेके हुआ है ना?
372
वो 372 हुआ और 7 लेंगे तो 15,782। तो ये वाला जो सेकंड डॉट है, मतलब अकॉर्डिंग टू यू एज अ काउंसिल, दिस शुड बी द
अगर सिर्फ एग्रीकल्चर होगा तब तो अभी 25,000 चला जाएगा।
सिर्फ एग्रीकल्चर नहीं ले सकते ना,
नहीं है सर।
सिर्फ एग्रीकल्चर नहीं ले सकते।
जो है यही सेकंड डॉट पर
यहाँ पे भी जो है डेट में भी जो है 4 ही कैटेगरी है, एग्रीकल्चरल, इंडस्ट्रियल, रेजिडेंशियल एंड कमर्शियल। देयर इज नो सच कैटेगरी एज नॉन एग्रीकल्चरल, ऐसा कोई कैटेगरी ही नहीं बना है सर्कल में। देख रहे हैं आप सर्कल रेट आपका, देयर इज नो सच कैटेगरी एज नॉन एग्रीकल्चरल। देयर इज एग्रीकल्चरल, इंडस्ट्रियल, रेजिडेंशियल एंड कमर्शियल। कोई और तीसरा चौथा कैटेगरी बंजर भूमि बोलकर कोई क्लासिफिकेशन नहीं, क्लासिफिकेशन ही नहीं है आपके सर्कल रेट में। यस
ये चार्ट फाइल की है इसी में।
आपने
हाँ पेज नंबर 5
बताइए।
बंजर का तो हो गया नॉन फर्टाइल एग्रीकल्चर।
आज के दिन में कोई भी जमीन जो है ना नॉन फर्टाइल नहीं हो सकती।
आप जब ले लिए तो इंडस्ट्रियल में
रोजबाग लोग बालू में धान उगा रहे हैं, किस दुनिया में है?
इसमें चार्ट में जो कंसीडर किया गया है वह करना है।
हाँ।
नंबर 3, 4, 5, 6, 7, 8 और 11 ये बेसिक है।
ये 7 का एवरेज आपने निकाला। 3, 4, 5, 7, 6, 3, 4, 5, 6, 7, 8 and 11. आप कोई जजमेंट इन पर्टिकुलर रेफर करना चाहते हैं? Say जी, do you want to refer to any particular judgment?
Judgments are before this act. And
So
one
we can
judgment
omit
for
it.
4127 may I am referring to
हाँ, that
judgment
will take it.
because that says that if anything is concealed or not brought
Yes,
in
yes.
perspective analysis, then it is, and ultimately 4127 it gives whole jurisdiction to the court in the interest of justice. We can look into any document
That's right.
to meet the aims of justice.
That's right. And the duty of the court is to ensure that proper compensation is paid.
Yes, striking balance that ultimately state exchequer should not be overburdened with this, because ultimately taxpayer is liable. The individual should not be benefited at the cost of taxpayers. Just and fair, that is what it says.
NTPC is a profit-making organization. State के साथ equate नहीं करनी इसको.
So we are in power generation with a huge investment and huge employment with huge CSR facilities.
With huge profit-making.
No, huge. Where is the profit making? I am a government undertaking.
See,
Ultimately, I will also become HEC.
Profit-making is an integral part of every industrial activity.
Yes, yes.
Provided, irrespective of the fact whether it is a government organization or it is a private organization, this is the order of the day,
Yes.
right?
Or else it will be a Titanic like HEC.
Tell you. We heard the learned counsels appearing on behalf of the parties.
So I stood by my commitment. I want to tell you.
Yes.
So next time you don't say that my request that you will take adjournment. I
Okay,
never take
possibly.
adjournment. This kind of
आपको इसीलिए बोलते हैं कि you take adjournment जिससे आप adjournment ना लें.
हम कभी adjournment लिए
In
हैं?
anticipation.
कभी हम लिए हैं? You look into the report. 400 cases disposal was there. I came. It was running for months together before I assumed my office.
और हम लोगों ने कितनी मेहनत की आपको कोई
आपका तो
idea
मेहनत का तो दाद दे रहे हैं, आपको छुट्टी लेके उसी काम में you use your holidays.
Sindhu, how much time will you take to complete the party finish? ये बता दीजिए.
I know.
हाँ? 15 days. कुछ slow नहीं है? 112 cases.
No, 400 cases हो गए.
नहीं इसमें
इसमें हम 180.
180 cases. 118 cases.
59 into 2. We always assist in bigger matters for a bigger result.
I'll tell you one thing. The appellant in the Union of India matters, this NTPC matters, the name is same, right? So you can just put it like this, appellant in these cases. सीधा एक बार में उसको दोबारा टाइप करने की जरूरत नहीं. Respondent in this private matters, they are the same, एकदम same, तो वो एक common दे दें, ठीक है? चलिए. Heard the learned counsels appearing on behalf of the parties. Both the parties have furnished their synopsis of argument before this court. During the course of hearing, yes, the learned counsel for the appellant has submitted that a petition under Order 41 Rule 27 has been filed before this court, placing on record numerous sale deeds executed by PW1, who was also one of the claimants of the case, but he did not bring the same on record, which amounts to material suppression on the part of the claimants. He submits that for proper adjudication of the case and in order to fix compensation payable to the claimants as per law, the additional evidence may also be taken into consideration. He has also submitted that the appellant is a beneficiary of the entire land acquisition proceedings, as the land has been acquired for the appellant and they came to know about the sale deeds placed through additional evidence when the claimants placed those sale deeds before the authorities. He submits that if the additional evidence is taken into consideration, the quantum of compensation would come down. The learned counsel has also submitted that the compensation was rightly fixed by the concerned authority and the same did not call for any interference. He has submitted that the core issue to be decided in this case is as to whether the determination of compensation by the learned court of the principal district judge cum LARR capital A Haribab is in conformity with the provisions of section 26 of the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act, 2013, in bracket wherein after referred to as the act of 2013. The learned counsel has further submitted that has furnished the relevant dates in connection with the proceedings which are as under the first page cylinder. He has also submitted that the land acquisition proceeding under the 1894 Act lapsed and therefore on 29th April 2016, fresh application for initiation of land acquisition proceedings was fresh application was filed for initiation of land acquisition proceedings, and after completing the required formalities, the notification under section 11 of the aforesaid Act of 2013 was published on 12th of June 2019, whereby the total land to be acquired with respect to the village Tarhisa was 84.80 of Rayati land. He has submitted that as per the provisions of section 26, the 3 years was required to be taken with reference to 29th of April 2016 and not with reference to 12th of June 2019. And therefore, the approach of the learned court by taking the average of the same deeds half of the sale deeds produced, that is total 16 in number, within bracket 8 of the 8 sale deeds was not in accordance with law. The learned counsel submits that the impute judgment suffers from gross illegality for the following reasons. A. No reason has been assigned why circle rate has not been considered, which rather was of the year 2020 and mandates as per section 26 within bracket A of the Act of 2013. B. Explanation 1 of section 26 of the Act of 2013 was not considered in its full perspective. And C. Sale deed for the same village, that is the Resa, existed to which the claimant himself was a party. The same deeds with respect to the land which was acquired, and as such, the best evidence was required to be taken to ascertain the value. And additionally, by way of additional documents, the appellant has brought on record the sale deeds to which Ram Swarup Ojha was a party, which revealed that the rate never exceeded rupees 5,000 to rupees 6,000 per decimal for village that's. During the course of hearing, the learned counsel for the appellant has submitted that has relied upon the judgment passed by Honorable Supreme Court reported in bracket 2022 bracket close 7 SCC 247 to submit that the application for additional document can be allowed if the document removes cloud of doubt and is directly linked to the main and important issue. He has also relied upon the judgment reported in Manu/MX/1653/2021 party का नाम सब डाल to submit that application for additional documents can be allowed when there is material concealment by the parties. So far as the other judgments which has been referred in the written submissions are concerned, the learned counsel has submitted that they may not be relevant as they relate to the land acquisition proceedings under the Act of 1894. Is that correct, Council? You have said so? That other judgments are not relevant?
Yes.
ये जो आपका written submissions है ना, इसका pendant दे देंगे. The Learned Counsel appearing on behalf of the Learned Counsel has further submitted that so far as the appeal filed by the claimants are concerned, there is no merit in the same. Rather, the compensation is required to be reduced. Yeah. The Learned Counsel for the claimant has submitted that the additional that the cutoff date which is required to be taken is 12/6/2019, when the notification under Section 11 of the Act of 2013 was made. And therefore the period would be, the period for which the sale deeds could be considered are from 12/6/2016 to 12/6/2019. He submits that even the authority has taken this particular period for consideration and fixation of compensation. The Learned Counsel further submits that so far as the additional evidence is concerned, all the sale deeds mentioned therein are relating to the period prior to 12/6/2016, and therefore the allegation that the claimants had suppressed material facts before the authority and is not correct. He has submitted that those sale deeds are of no consequence when seen in the light of Section 26 of the aforesaid Act of 2013. The Learned Counsel has further submitted that even the circle rate has no relevance in view of the fact that circle rate was less than the computation on the basis of sale deeds placed on record. During the course of hearing, it transpired that altogether 16 sale deeds were produced, and out of them, 2 were for the period 12/6/2016 and was with respect to the village involved in the present case. And the others were falling within the period 12/6/2016 to 12/6/2019 and were of the villages in the vicinity. To this, the counsel for the claimants has submitted that only 14 sale deeds could have been considered, and out of them 50% of the highest value were required to be considered in terms of Section 26 of the Act of 2013, and the average of 7 sale deeds was required to be considered. He has submitted that the Learned Court has taken average of 8 by considering all the 16 sale deeds produced by the claimants, although 2 were required to be excluded if the period from 12/6/2016 to 12/6/2019 is taken into consideration. And he has also given the calculation with respect to the highest value of 7 sale deeds. If 2 are excluded, which comes to rupees 15,782.71 per decimal. The Learned Counsel has also submitted that the rate for agricultural land has to be taken at half of the rate of residential land, which would be in line with the circle rate, wherein As per the circle rate also, the rate of agricultural land is half of the residential land. He submits that the compensation which has been awarded is at the rate of 15,372 per decimal.
11,000.
Okay, has been awarded is at the rate of 11,000 per decimal, although there is no basis to deviate from the average of the best 7 savings, which were fit to be considered as per the Act of 2013. The Learned Council has given the chart of the entire sale deeds, giving the rate per decimal, in the following manner. ये चार्ट लगा दो.
The short synopsis.
वो तो हम लिखे हैं. That's all. The Learned Council has submitted that the argument of the Learned ASGI representing NTPC Limited, that 3 years prior to 29th April 2016 is required to be considered is misplaced, and the cutoff date would be 12th of June 2019 and not 29th April 2016. Concluded? Arguments concluded? अच्छा एक चीज़ और ये भी ना बोल रहे थे, इसमें क्या चीज़ था? हाँ, the Learned Council for the claimants has relied upon the judgment passed by this court in AP number 298 of 2013, decided on 16/7/2025, and has referred to paragraph 26 and 27 of the said judgment, and has submitted that there was no occasion to deviate from the average of the best 7 sale deeds which were produced before the court. Sorry? हाँ, इसको ले लो. आपका ना ये सब रिटन सबमिशंस का जो भी रहेगा, ये जो ऑर्डर अपलोड होगा ये, तो वी विल इनकॉर्पोरेट दैट. आपका कहाँ है? आपका रिटन सबमिशंस का पेन ड्राइव कहाँ है? सॉफ्ट कॉपी है ना, तो प्रोवाइड करिए फिर. है आपके पास अभी? हाँ, तो ये इनको दीजिए पेन ड्राइव, उसी में डाल दीजिए और इनका पेन ड्राइव वापस करिए, कॉपी करके वापस करिए. ये दोनों एक साथ बांधिए तो 1 2 3 पंकज जी, ये सारा एक ही में बांध देते हैं, ठीक है? ये रिटन सबमिशन है इनका. और सेक्शन 26 को एक चीज और छूट गया है. The Learned Council for the Appellant has submitted that the calendar year is required to be taken into consideration, and the 3 years will not be relatable to the date on which notification under section 11 is issued.
Rather the year which has been mentioned in the section 366 of general clause.
He has referred to section 366 of General Clauses Act and submits that that year necessarily means
British
calendar year.
Yeah, British.
एक बार हम खाली ठीक है क्लियर कर देना चाहिए, चाहते हैं कि स्टैट्यूट में लिखा है जो ईयर बोल रहे हैं उसी को हम क्लियर करें. Provided that the date of determination, date of market value shall be the date what? the date on which the notification has been issued under section available here नहीं है.
That's right. The learned counsel for the claimant has opposed this submission by referring to section 26, first proviso, and submits that the referable date is the date of notification under section 11 for the purposes of determination of market value, and therefore the same is not relatable to calendar year. And the definition of year under General Clauses Act will have no applicability to the Act of 2015.
पैसा वहाँ एक्सक्लूसिव में जमा कर दिया था उसको काम करके जमा कर दिया.
इन्होंने जमा कर दिया है, तो अभी क्या करेंगे? अभी आ जाएगा जजमेंट, थोड़ा वेट करिए, टाइम लगेगा लेकिन आ जाएगा. कुछ पहले के सीएबी है इसीलिए पहले उसको निकालिए. लेट्स फिगर इट आउट. यही दोनों रिकॉर्ड है हम लोग का, समझ गए ना
जी.
ये दो रिकॉर्ड, यही दोनों पंकज एक साथ और बाकी सब में कुछ नहीं. इट इज द आर्गुमेंट्स हैव बीन एडवांस्ड फ्रॉम FA number 36 of 2026 filed by ATPC and FA number 78 of 2026 filed by claimant, and it has been submitted that for all the appeals filed by ATPC, the records in connection with FA number 36 of 26 would be sufficient, and for all the appeals filed by the claimants, the records of FA number 78 of 26 would be sufficient.
From the daily call list at 2:50 under heading for hearing item 1, criminal appeal SJ 808 of 2005.
For now today, there is a device in the family of the council.
Who is the counsel?
Gopal Krishna Sinha. And it may be kept next week.
दो बार लास्ट चांस आपका हुआ है, कोई बात नहीं, आई गिव यू टाइम.
Device हुआ हुआ है.
हम टाइम देख कहाँ मना करें,
जी.
लेकिन आप बताइए कब तक ये.
Next week any day.
Counsel for the appellant is present. Nobody appears. Are you for the state? Are you for the state?
Yes.
Counsel for the state is also present. Nobody appears on behalf of the informant. Counsel for the state submits that in the appellant कौन है? Advocate कौन है? Appellant.
Gopal Krishna Sinha.
In the family of the counsel for the arguing counsel Gopal Krishna Sinha is unable to argue this case today on account of his personal difficulty. It is submitted that the matter may be posted next week. Post this case on next Monday for final disposal.
Item 2, Criminal Appeal SJ 997 of 2005.
इन्फॉर्मेंट की तरफ से कोई एक्शन किस सेक्शन में पनिशमेंट है?
307. I think matter has been compromised between both of them.
कंपाउंडेबल है.
Compoundable 307. रोड कोर्ट में भी compromise पिटीशन ज्वाइंट compromise फाइल हुआ तो यहाँ भी फाइल हुआ है लेकिन compoundable 307. 147 में 123, 148, 307, 148, 307, 379 और
307 में कितने साल का सजा?
7 maximum 7. 1, 4 and 5. Appellant number 4 and 5. My lord, appellant 5 and 6. My lord, appellant number 5 passed away. He died on. And appellant number 6 is dead. हाँ, नंबर 5 केस कर गए हैं। हाँ, और जिसको 7 साल है उसमें एक अपूर्व पंडित अपना नंबर 6।
अंकुर पंडित पर स्पेसिफिक एलिगेशन है।
मर।
दो पर।
मर।
अनिल पंडित और अंकुर पंडित।
मर।
और अनिल पंडित का डेथ हो गया।
मर।
अंकुर पंडित है।
लेकिन लेट डिस्प्यूट आया है दोनों के बीच में लेट डिस्प्यूट है। पिछले 2-3
इंसिडेंट तो हुआ है ना। बंदे को चोट लगी है।
मर।
इसीलिए इंसिडेंट तो हुआ है, इसमें कोई डाउट नहीं है। जिसमें डिस्प्यूट होगा वही ना, आदमी जाके अमेरिका में थोड़ा जाकर किसी से लड़ लेगा, पड़ोसी से ही लड़ेगा जिससे लड़ाई होगा। लैंड डिस्प्यूट हो चाहे कुछ भी हो। अब आप बोलते हैं कि कॉम्प्रोमाइज हो, तो आपका क्या प्रपोजल है, क्या होना चाहिए बताइए।
अपना कोर्ट का भी है कि
हम तो 307 में कर दिए हैं। नहीं, थोड़ा विद इन लॉ देख करना पड़ेगा ना, ऐसे तो नहीं कर सकते। इसीलिए समझने की कोशिश कर रहे हैं कि अपील में हम कितना कर सकते हैं। कस्टडी कितना हुआ है? कोई मिनिमम सेंटेंस है किसी में भी?
हाँ है।
किसमें है मिनिमम सेंटेंस?
मिनिमम सेंटेंस है 147, 323, 148, 379।
तो मिनिमम सेंटेंस पार हो गए हैं?
हाँ पार।
और 307 में कोई मिनिमम सेंटेंस नहीं है? 307 में क्या सेंटेंस है? सीधा सीधी 7 इयर्स।
7
अप टू 7 इयर्स तो नहीं है?
नहीं, अप टू 7।
वो तो सीधा सीधी 307 में तो 7 इयर्स दिखाई जरा आईपीसी। ये कॉम्प्रोमाइज ट्रायल के समय हो गया था? तो विटनेसेस हॉस्टाइल हो गए थे?
नहीं, हॉस्टाइल नहीं, लेकिन उसके बाद में कंप्रोमाइज, ये जजमेंट में ऐसा आया है कि वहाँ पर कंप्रोमाइज का जिक्र है, और वो आयु भी गवाही में होता है। PW8 आयु है, ये भी गवाही PW है, वो भी बोले हैं कि कंप्रोमाइज। और यहाँ पर जब अपील हम लोग फाइल किए तो यहाँ जो भी ज्वाइन कंप्रोमाइज
उसी पर बेल हो गया होगा।
माइक
Punishment for imprisonment of either description for a term which may extend to 10 years. Minimum sentence नहीं है कुछ। And also be liable for fine. क्या करेंगे बोलिए? बताइए क्या करना? सुन लिया, बताइए क्या करना? कल करिए। देखिए आई टेल यू वन, कन्विक्शन हो गया है, पड़ोसी हैं, भाई हैं, कौन है?
सब पड़ोसी भाई लोग हैं, अपना
सब
अपना सब एक कौन को इसलिए कंप्रोमाइज
कौन को किया है? बताइए कुछ करेंगे। खाली ये अंकुर के साथ थोड़ा दिक्कत है। अंकुर पर डायरेक्ट एलिगेशन है, मेन असेलेंट है। बाकी का देखते हैं कुछ करेंगे। 148 तो लगा हुआ है।
आइए PW11 में उस समय भी हुआ था कि यह शुभारनामा का आवेदन उसकी लिखावट हस्ताक्षर में से में पाता है, वहाँ भी शुभारनामा का प्रयास किया गया। उसमें भी एक PW
कल करें? कल करते हैं, देखते हैं।
डे आफ्टर टुमारो।
कल छुट्टी पर है?
नहीं छुट्टी पर
हम नहीं है छुट्टी।
नहीं
क्या है ना, हियरिंग मैटर्स में एक बार फाइल खुलने के बाद दूसरे के साथ मिक्स हो जाता है, फैक्ट्स मिक्स हो जाता है, चीज़ें फिर दिमाग से निकल जाती हैं, तो इसमें दिक्कत है। थोड़ा सा देखिए, हम भी देखेंगे कि क्या रिलीफ किया जा सकता है। जब आप लोग कॉम्प्रोमाइज़ किए हैं तो हम सोचेंगे क्या रिलीफ किया जा सकता है। स्टेट के असिस्टेंस आप वैसे हमको बोलना तो नहीं चाहिए, लेकिन अगर अच्छा होता हम मिस्टर पंकज कुमार को ले आए, क्योंकि वो एक आध केस में हमको असिस्ट किए हैं। नाम आप ही का रहेगा, लेकिन उनसे प्लीज़ रिक्वेस्ट करेंगे, कॉम्प्रोमाइज़ का मैटर है तो बहुत ध्यान से हम लोग को करना है, एरर नहीं है। ठीक है, वो तो आपसे बहुत सीनियर है ना, प्रैक्टिस में हमसे भी सीनियर। और उनके क्रिमिनल मैटर्स में उनके लीगल एग्रीमेंट का बहुत रिस्पेक्ट करती हूँ। अगर हो सके तो जस्ट रिक्वेस्ट कि कॉम्प्रोमाइज का बात चल रहा है 307 का है, थोड़ा सा एक बार दिखा लेंगे, ठीक है। The hearing has commenced. Post this case for further hearing tomorrow at 2:15 on the basis of